Yes, Mr. Settright.
My lady and my lords, taking matters now relatively speedily, and finishing off on the topic that I was on, when one looks at anticipatory retention, and the court has already to some extent raised this with me, it's demonstrable that an actual physical retention doesn't occur until the expiration of an agreement, whether that's an agreement which has legal force and effect or just an agreement between the parents.
Well, I'm sorry, I'm not sure that's right, is it? There may not be any, on your case, there's no possibility of a wrongful retention until then. But there is a retention, isn't there? In the same way as there's been a removal.
I am rightly picked up.
Yeah.
Not the possibility of a wrongful retention because no breach of rights of custody. Yeah. So if I come directly on to that, I've referred briefly to H and S in the House of Lords. The references, and I don't think, unless my lady and my lords wish it, I need to take the court into the authority itself, to the speech of Lord Brandon of Oakbrook, is MS pages 1368 to 1369, letter A on the first page, between letters D and D on the next. And it does, as I indicated, say that there is a clear distinction between removal and retention, and there is a fixed terminus a quo, in the Latin that was then commonplace. There is a fixed point for retentions, and there will only be one retention. And Lord Brandon, at the end, rejecting the core submission by my then leader, said it was submitted by Mr. Mundy that the word or, where it links removal and retention, should be construed as meaning and or. This again involves inserting into the convention words which are not there, and which could, if intended to apply, readily have been put in. I cannot therefore accept that submission. So there's Lord Brandon, as long ago as 1991, declining robustly, even though it meant the end of the two cases that were before him and the inapplicability of the convention, declining to insert a gloss and declining to interfere with the construction of the convention. So we say the question of breach must be considered in terms of the exercise of rights of custody. If there's a joint taking of a parental decision that a child should leave the country for a period of time, is there a subsequent breach of a right of custody, a wrong act? And parents can, we say, change their minds. There is a difficulty and a hazard in venturing into this territory. We say that to hold that a retention is a breach of rights of custody before there is, on the face of it, a wrongful act, but merely the intention that in the future there may be a wrongful act, which may or may not lead to that wrongful act actually being committed, is beyond the scope of the convention. We have dealt with that more fully between MS 53 and 54 at our written case. But what I'm going to do, if I may, is to go on to how the Court of Appeal dealt with rights of custody. And there, I need to take my lady and my lords to MS 189 to 190 and paragraphs 124 to 127 of the judgment of Lady Justice Black as she then was. And in many ways, that's the core of her judgment, and it's her judgment that the majority of the court also relied upon in this context. So if I may, I will attempt to dissect it. And at paragraph 124, she indicates that nothing in the wording of Articles 3 or 12 tells us that a wrongful retention occurs only at the end of an agreed stay, but there's nothing to say that it can occur before that point. At 125, she recites, with respect accurately, the submissions made to and that by Article 5, rights of custody include the right to determine the child's place of residence. It might be said that that is the quintessential right of custody under this convention. And Lady Justice Black agreed it extends to a right of veto to the child residing in a particular country. That's the international standard accepted by the United States Supreme Court. And the submission, there can't be a breach before the agreed return date, the breach being the failure to return at the end of the period. Lady Justice Black said, I accept entirely that it's essential to have regard to the need to identify a breach of rights of custody. But I don't agree that such a breach can only occur at the end of the period of agreed stay. And she then looks at an example. Section 13 of the Children Act, to which I've already referred, my lady and my lords, in outline. A parent named in a child arrangements order as the person with whom the child is to live is permitted to take the child abroad for a period of less than 1 month. That is to say, without the need for any formalisation, including the need to approach a court. Suppose, say, counsel, that 7 days into the trip, the parent announces they're not bringing the child back. They submit that this would generate a flurry of concern and activity, but there would be no breach of the law or of custody rights until the child was not returned at the end of the month. I interpose, or I interpolate, that of course, if the father was sufficiently concerned by, if the parent who was left behind in the process was sufficiently concerned, he could make an application to the court. But there wouldn't be a breach. Lady Justice Black goes on at 127. I agree that in a Section 13 situation, there would not be any breach of custody rights until the end of the month, unless, of course, my example, a court order were to be obtained from the domestic court requiring an earlier return on welfare grounds. Therefore, the paradoxical situation, my lady and my lords, that if one has, for example, an order made by the Family Court of Australia that permits a retention in England for up to 12 months, and if a month in, the mother says, I'm not going to obey that order, I am going to retain beyond that period, that would not be a wrongful retention as defined by Lady Justice Black. She goes on, similarly, if a parent were to announce in advance an intention not to return at the end of a court-authorised stay away, I do not think that would be a breach of rights of custody, unless and until a variation of the order was obtained, requiring an earlier return. Well, that's bold and clear, but the judgment then goes on. I was initially attracted to the idea that parallels might be drawn between these situations where absence is permitted by statute or court order and absences agreed between the parents. Just pausing there, we invite this court to be attracted by it also, but attracted by it with determinative effect. However, upon reflection, I think there is a strong case for viewing agreed periods abroad differently. It seems to me that there's a contrast between a situation set up by court/statute where the permitted stay can only be curtailed by intervention of the court. Just pausing a moment there, thus eliminating at a stroke the ability of parents agreeing between themselves to vary a situation which has been regulated by a court, and a situation set up by the parents themselves. The parental agreement is predicated on the undertaking of the parent who is taking the parent abroad that they will be returned at the end of the period. He or she has the benefit of taking them abroad and the burden of returning them. To echo Mr. Justice Wall, as he then was in S. Once that parent casts off the duty to return them at the end of the stay, the basis for the agreement is removed, in contrast to the Section 13 permission or the court order which remain. It seems to me that in legal theory, those being Lady Justice Black's words, in legal theory, it must in those circumstances be possible for retaining the children abroad to constitute a breach of the other parent's rights of custody, even though the date originally fixed for their return has not yet arrived. Whether there is in fact such a breach will naturally depend upon the attributes of the left-behind parent's right of custody and the facts of the particular case. Well, my lady and my lords, we say that, with utmost respect, Lady Justice Black fell into error there, that the distinction that she makes is not an apposite distinction, particularly in the context of an instrument like the 1980 Hague Convention, that she falls back to consider the matter in terms, I suppose, of something analogous to the laws of contract, which is, we say again, not appropriate when looking at this particular convention. And we suggest, with all due deference, that the approach which operates with agreements having legal effect should also operate with those that are made more informally.
If a wife, by deception, secures her husband's agreement to allow her to take children abroad, never intending to return them, is that a breach of his rights of custody?
That might be a wrongful removal.
Well, it may well be a wrongful removal, but I'm more interested in the moment in whether it's a breach of his rights of custody.
Well, it's only a wrongful removal if it's a breach of his rights of custody.
That's right.
But
Yes.
so securing the consent by
Yes.
misrepresentation or fraud or whatever,
That would be the arguable analysis of that.
What's the difference in principle between someone who secures by misrepresentation the agreement of her husband, but within, let us say, a very short time of departing, decides that she's not going to return the children to him?
I suppose, my lord, that although it's not a point that's engaged in this appeal,
Right.
the point might very well be that there was in fact no consent at all, because there was an operative deception. Whereas in this case, there was undoubtedly a consent, and there was a consent for a particular period. But, my lord, I have to say that that's an arguable point also, not one which I think has been run to earth definitively.
Yeah.
But my lord is right to alight upon it, because sometimes it's an argument that where within a day or so it becomes apparent that a holiday is in... I mean, if one takes an example where the removing parent for a 2-week holiday has in fact made firm preparations to live in the other jurisdiction and has taken with her 14 packing cases of possessions secretly, well, that would tend to call into question whether consent, parenthesis, had been achieved by a deception. But this is a different context. So we say that the agreement and any alleged breach of the agreement is insufficient without something more. We say Articles 3 and 5, to which we've taken the court, don't protect parental agreements unless they have legal effect under the law of the contracting state in question. There's no evidence that in Australia, and that takes me back to the matter to which I was asked to do some construction by my Lord Carnwath in terms of the definitions in Articles 3 and 12. If one looks at the law of the contracting state in question, we know, and it appears in the judgment, that under Australian law, there is no anticipatory retention that is recognised. And if I was to look at MS 177 in the judgment of the Court of Appeal, there is Lady Justice Black's analysis from paragraphs 91 to 93 of the judgment in the Director General Department of Families and BW in the Family Court of Australia, where at 93 it's observed the core of the reasoning was there is no reason in this case nor authority to support the proposition that the court should find that the retention occurred on the date on which the mother told the father that she'd not return the child. According to the agreement, for that's all it was, the child was not due to be returned until 20th of January. Despite the mother's earlier threats, she was entitled to retain the child until the 20th of January, no wrongful retention. And so we say that the focus on the agreement and not the rights of custody that underpin that agreement was an error and shouldn't be supported by this court. We provide our conclusions in summary on rights of custody between MS 79 and 81 in our written case, and it may be I will be forgiven for not taking my lady and my lords to them, but going on to ground 2 and dealing with it shortly. If the court is against us on ground 1, then we say that unless there are to be significantly dire consequences for Hague Convention cases, the ground 2 appeal and the conclusions in the minority judgment of Lady Justice Black are absolutely essential. It would be a policy decision by this court, and it would therefore be a gloss, but it is almost unthinkable that the sort of open season that would result if the judgment of the majority was to stand could be permitted. And
I must say I'm very concerned about this acceptance by Lady Justice Black that this is a policy decision, which is something you've just endorsed. I mean, that's likely to be looking at it from the wrong end of the telescope, isn't it, Mr. Setright? We must make a principled decision, mustn't we?
yes, there are 2 points to make on it. The first is that the right approach is the determination on ground 1 that we seek, and if the consequences of the determination that's sought by the respondents on ground 1 is to produce the potential chaos which would require a policy decision, then it may very well be the wrong answer. But otherwise, it's not a policy decision. With respect, my lord is quite right. It's a decision of principle on how these cases must be dealt with.
Can you say in a sentence, if it's convenient, what you say should be the test? You're going to say that it must be communicated, but what do you mean by communicated? Objectively apparent, spoken by the travelling parent, him or herself, or what?
I don't think I could specify a means of communication, but there must be a visible,
Yes.
evidentially
Something objectively apparent.
apparent
Okay.
means of communication. Anything less will not do. It can't be a suspicion. It must be something different. It could, of course.
That's an incentive to duplicity, isn't it?
If, my lord, one looks at the very last paragraph of the judgment, one sees that what the majority of the court was concerned about was that the modern law on habitual residence might encourage a situation where one parent, on the strength of an agreement that a child can remain in this country for some time, may produce a situation in which recourse to the Hague Convention is lost. Underlying the whole of this case, and the whole probably of the judgments of the Court of Appeal, was the concern that somebody might pull a fast one and try by those means, by otherwise legitimate means, to disenfranchise the left behind parent. That's on the one hand, and we say that's wrong because there are other remedies available. But if one looks at anticipatory wrongful retention, if one says there has to be communication, yes, there will be cases where there are secret thoughts which are effectively kept from the other parent. But that is a price to be paid for certainty. If one looks at it in the other way, and one can see, with great respect, my Lord, counsel making attractively and with force exactly the point that your Lordship has just made to me, to justify an application to a judge to look at a string of emails, to look at a diary, to cross-examine at some length, to determine what really was in somebody's mind. Well, that was in your statement on date X, but when did you see your solicitor? When did you form that view? Yes, you put the child into school, but when did you visit the school? When did you ask for a prospectus? There wouldn't be an easy limit, and one would be thrown back on a process which is decidedly unsummary, which would entail looking very closely, almost certainly on oral evidence, with a judge making a finding of fact on credibility as to what had in fact happened.
Those are germane to the question of forming the intention to retain. I don't see that they're particularly pertinent to the question of why there must be communication.
Communication by some means.
Is your case that the requirement for some kind of objective sign avoids the evidential difficulties?
Yes.
It's to avoid the complications of the procedure, is it? That's your case.
That's the principal argument.
But you do get that in here. You shouldn't, of course. The time was when they were always done in a couple of hours on a Friday afternoon, but those seem to have gone.
They have.
But you will get questions of fact, won't you, in Hague cases? For example, you have the cases where there's a dispute about what the agreement was.
Yes.
And you're going to have oral evidence about that. And you're going to look at the emails and the letters and who said to who else.
If one looks at the postscript to Lady Justice Black's judgment, there she deals with the points, having learned what it was that the majority were saying. And paragraph 174 onwards, she deals with it. At 175, she says, in many ways, the decision as to where the boundaries of anticipatory retention should be set is a policy decision, there being little in the wording of the Convention to fix parameters. She hoped that her view, communication, would avoid far-reaching trawls through all conceivable aspects of the lives and correspondence of the parties and of the parents and the children, both in pre-trial preparation and in evidence at court. There's support in a number of decided cases for rejecting uncommunicated decisions and acts as insufficient. And if communication/knowledge is insisted upon, it has at least a prospect of improving certainty and focus. The court will be looking for something known to the applicant, and that is, I suppose, a key, as well as the need to have a fixed point in evidence which can be defined.
There might well be an argument that a simple intention on the part of, let's say, the mother, not acted upon in any way, wouldn't be enough.
Yes.
But if there are acts, if on analysis, and this probably isn't, may well not be the case, you looked at the September, October, November application for Home Office citizenship, and you found that there was a clear expression to the Home Office that the children would be permanently living in England if the mother had anything to do with it, then wouldn't it be odd if that act of presentation to them wasn't going to be enough just because over in Australia the father knew nothing about it because the mother didn't tell him?
The difficulty, my lord, would be that because the mother didn't tell him, it may not have the substance that the left-behind parent seeks to place upon it. It may have been done for all sorts of reasons, and the potential would be for the evidence to be drawn out. This is why I made the application. I didn't necessarily intend to say I just wanted the children to have a UK nationality, or I just wanted to test out the school. I just wanted to see what might be available. If the school writes to the father and say, well, delighted that the mother's made an inquiry to the school.
Well, then that would lead to a conclusion that irrespective of communication, there was no sufficient decision to retain beyond 26 June.
Well, it isn't easy, my lord, because we say that Lady Justice Black's requirement for communication is a fallback position, but we say it's a necessary fallback position if one is going to adopt an anticipatory wrongful retention. Now, my lords, I think that I have run myself up to the point where my time finishes. I can say, my lords and my lady, that we've summarised in our written case the objections to uncommunicated retention, uncommunicated wrongful anticipatory retention. May I simply see whether there's anything that I've missed?
Well, could you give us, firstly, remind us of the references in Lady Justice Black's judgment where she decides that the intention has to be communicated so that we can interrogate her reasoning.
MS 190.
Sorry, say that again, please.
MS 190.
Thank you very much.
And onwards to 133? To 133.
Then again, paragraphs 172.
Which I took my lady and my lords to.
Of course, the ironic thing about all of this is that supposing you've got, as she points out in somewhere, that if you've got a long agreed absence and somebody forms an uncommunicated intention early on in the absence, you're going to be up against the settlement rule. If it doesn't become clear until much later on, you may be up against the change of habitual residence point, although for the reasons we've just been exploring, that's by no means straightforward. And in any event, there are definitely alternative remedies.
Yes.
So choosing between the least of two evils is quite difficult. Is it a policy question or is it what's the right answer?
Could I ask a purely principled question? If it doesn't admit of a simple answer, say so. Can you envisage a situation in which a child is settled for the purposes of Article 12, but his or her habitual residence has not shifted, or vice versa?
If you'd like to think about that, Mr.
Yes,
Fisher,
please do.
and return to it in reply, for which you've given yourself lots of time,
I just wanted
you're
to...
welcome so to do.
Yes, that's
But I think
helpful.
we'd like the answer.
I wanted to flag it up because it'll arise later.
Yes, my lord. I will take up, my lady, the President's offer.
Well, my Lord has been reminding me, what are we going to do about the application for permission about ground 3? What would you like us to do?
Well, what my lady encouraged was that we should, until the position on grounds 1 and 2 were clearer,
Yeah.
that we should avert our gaze and indeed our mouths from articulating both ground 3 and, in my learned friend's case, the cross appeal. I'm in your ladyship's hands. If your ladyship were to be against us on grounds 1 and 2, then ground 3...
You would be arguing ground 3 with enormous vigour for the reasons given in your written case. But we have to spend the limited time available to us on the principled arguments rather than on the factual arguments, it seems to us. If we feel the need to revert to you on that, well, we will tell you.
Both are probably, mostly, a question of quoting references from the evidence to the court.
Yes.
An unusual exercise for advocates to this court and an unusual exercise for this court to look at them.
But sometimes it has to be done.
Sometimes it has to be done.
So you'll have your lists prepared.
We do.
Yes.
Anything else?
I think that's the best we can deal with it at this stage. Thank you, Mr. Setright. Mr. Gresham? Yeah. Mr. Hale?
My lady, my lords, I'm tempted to start my submissions, my lord, in answer to your question with the word unicorn, because in reality, my lord, it is inconceivable that there would be a decision of settlement, but the habitual residents have not changed. But can I go back to the beginning, if I may? My lady, the father in this case is not present in court. He's in Australia. He would have been here, but for the fact that he has a 6-month-old new baby, and he feels rightly duty-bound to assist his partner in the care of his new son, and so can't be in this court. But, my lady, coming late to this case, I can tell you that I had my self-conference with the father, and he remains as committed to his 2 children, P&E, in this case, as he ever was, and committed to this appeal.
Well, presumably he's been told that he can watch these proceedings online.
Yes, my lady, indeed.
I know the timing will be a bit inconvenient, and
Well, he might be up anyway, I suppose.
yes, bearing in mind the reason that you say he's not here.
Indeed. Indeed.
I mean, but you don't have to answer this, but is his position that the best interest of the children require them to go back to Australia?
My lord, I'm concentrating on the grounds of appeal and, of course, in support of the judgment in the court below, rather than that decision, which may be a decision that has to be considered after my lords come to decision in this case.
Well, it would take place on a much wider canvas than is available to us.
Indeed.
In any event.
It's
Indeed.
irrelevant what's in the best interest of the child in Hague
this
Convention
stage.
proceedings.
Indeed, my lady. I wanted the court to be clear about the father's position because he couldn't be here. But he was very active, as my lords, my lady knows, in the proceedings below, both in terms of the Court of Appeal and at first instance, where he gave evidence, and was very clear in terms of his statement evidence about in particular, the agreement between his parents. And the starting point in this case has to be, my lady, that these were 2 parents living in Australia who had come to an agreement about where the children should be, but be temporarily. My lady, some listening to the appeal today may have been confused to think that this court was dealing with an appeal concerning the Hague Convention of 1996, the inherent jurisdiction, and others. It's not. This appeal, my lady, of course, concerns the 1980 Convention and the rights under the 1980 Convention, notwithstanding the perhaps submissions and sidesteps in terms of that. My lady, this court before has indicated that notwithstanding there may be remedies under other treaties, that does not mean, or other principles, that does not mean the court does not focus upon the issue under the Hague Convention. My Lord Carmouth asked questions earlier this morning about rights of custody and the Hague Convention, my lords know, certainly the majority of this court knows, the very raison d'etre of the 1980 Convention was to deal, we say, with exactly the problem in this case, and that is where one parent refuses to return or abducts a child, either without the knowledge of the other parent or in breach of an agreement with that other parent. This is not a problem, and I move immediately to our submissions on ground one. The problem, my lords, my lady, in terms of what has been discussed in the authorities as anticipatory retention or anticipatory breach, we certainly, my lady, on this side of the case, grappled with whether or not we could come up with a different phrase, but were left with the same position that my Lord Hughes came to this morning, that this is really a question of wrongful retention. It's about whether the retention is wrongful.
I was wondering over the short adjournment whether premature retention might be an answer, Mr. Hale. The objection to anticipatory retention is that there's some innuendo that it isn't actually retention.
No.
And that, I think, is worrying my Lord Hughes in particular. What do you think of premature retention?
I figure it will incur sniggers elsewhere. But my lord...
Why would it?
Well, premature...
Says he, bridling.
my lord, premature... really, we came down after some conference on this point to going back to the terms of the Act, back to the terms of the treaty, and back, my lord, to my Lord Hughes' point, which is this is simply a retention that becomes wrongful. It happens to be at a time before the end of the agreement, and that really is the crux.
The question is whether it can become wrongful before the end of the agreement, isn't
yes.
it? Because it's what's said against you is it simply can't. The agreement's been given for a year, and there's nothing wrongful in retaining the child for a year.
And we say, my lord, boldly, that would be absurd. And there are very clear reasons why that is the case. But, my lords, I wanted to start, if I may, in reminding my lords, of course, that learned Lord Hughes and Baroness Hale envisaged this very problem, of course, in A&A. Didn't, of course, my lord, then go on rightly to deal with the problem because it wasn't central to the issues in that case. And referring, if I may, my lady, to MS page 1097, therein there lies the reference starting at paragraph 39 and then moving into 40. At paragraph 40, the father has not challenged that conclusion in this court. The question is not before us. It's worth noting that the rule...
Sorry, what hasn't he
I'm
done?
sorry, my lord. The rule, I was taking it far too fast, the rule at that stage was that a child's habitual residence...
Have unilateral change.
Exactly.
Yes.
And so, as my learned Lord Wilson said earlier, my lord, that significant change in the jurisprudence in this country to bring it in line with the European consideration of habitual residence has a consequence, and one of those consequences is that the actions of a parent may lead to the change of habitual residence, even if that's not agreed by the other parent. And so dealing with that, this issue was then, of course, envisaged, albeit not dealt with. And moving further down, the Hague Child Abduction Convention, I'm 2/3 from the bottom, is concerned with the wrongful removal or retention of a child from the country where the habitual resident immediately before the wrongful removal or retention. See Article 3. As Lord Hughes has pointed out, the rule is more relevant in retention than removal cases, but the answer may lie in treating the unilateral change of habitual residence as the act of wrongful retention, even if it takes place before the child is returned. And the matter may therefore require fuller consideration in another case, this case, my lord, but it's not necessary for us to express a concluded view. And then my learned Lord Hughes dealt with that point at MS 110, at paragraph 78, I agree. 1110.
1110, right?
Forgive me, 1110.
Very well.
Paragraph 78. And rather than reading that out, I'll turn, if I may, to the bottom of it, the significance of the point, starting in towards the second half. The significance of the point here is simply twofold. First, that Brussels II revised, notwithstanding, in the event of a conflict, it prevails over the 1980 Hague Convention, and clearly meant to coexist consistently with the Convention remaining effective. See, for examples 10 and 11. It ought to be construed wherever possible, with a very objective in mind. In particular, the concept of habitual residence needs to be construed similarly in each of the two instruments. And second, providing this approach is adopted, it's unlikely that even in this situation, it's necessary to formulate a rule of law that a child's habitual residence cannot unilaterally be changed by one parent where two parents both have parental responsibility. The point being that my Lord didn't see it, this problem, as a restriction to the alignment of our jurisprudence with the habitual residence jurisprudence of Europe. Now, it does, of course, throw up, as it has done in this case, the difficulty that this father has faced. Ultimately, my lord, my lady, we don't see this case, with the greatest respect to my learned friends, as quite as complicated as they do. This, we say, it is a case that can be ultimately dealt with by a simple law principle in line with learned Baroness's comments and learned Lord Hughes' comments, that as a principle, a wrongful retention can, in circumstances, take place before the end of a period of agreed temporary removal. Whether it is wrongful, it is a question of fact, having regard to the circumstances of the case. We say this case is a relatively obvious one. There are more obvious cases, of course, and my learned Lord Kerr alighted a little while ago on the suggestion that an element of deceit. Well, that deceit, of course, could take place after the child has been removed to a second state by agreement. That, again, we would say, if it wasn't possible for the left-behind parent in that situation to act upon the deceit before the end of the term, it would be legally absurd. It must be right that if in that circumstance, where, let's say, a mother travelling from the other side of the world, after a period of, say, 2 months within an agreed period of 6, simply said, that's it, I'm not coming back, that father, in those circumstances, must be, we say, legally entitled to action remedies under the Hague Convention.
That, in a sense, is the question, isn't it? Because the wrongful removal or the wrongful retention, as the case may be, is the trigger for the left-behind parent's remedies. Does it make, while it might make sense for the trigger to come where the left-behind parent had discovered evidence of unequivocal evidence that the person was not going to come back with the children on the agreed date. That is one thing.
Yes.
Quite a different thing if sometime after the event matters come to his attention. After all, in this particular case, he didn't know about the passport until very late in the day.
Disclosure within the
Exactly,
proceedings.
within these proceedings. So it is one thing to say the first of those things. It's quite another thing to say that his right to bring a remedy actually arose months before he had any reason so to do.
Well, my lady, Lady Justice Black, in her very lengthy judgment in the court below, dealt with what she called the spectrum of cases, and those at both ends, the very obvious ones and the very, very less obvious cases. But ultimately, my lady, we would say it's a question of factual determination. Dealing directly with your issue, though, it moves into ground 2 as well as, of course, dealing ground 1.
Yes.
dealing with that immediately rather than
Can I just, before you go on,
Moving back.
are we leaving ground one? Or?
no, my lord. I'm just, rather than sidestepping, I'm going to answer the question, if I
Well,
may.
you can park my question as long as you come back to it at some convenient time to yourself.
I've got two juniors, I'll make sure I will.
Yes.
My lord.
Well, I had 2 points on ground one. First of all, when we're looking at Article 3A, is it right that the question of removal or retention, which we're told has to be a fixed point in time, has to be considered separately from the question of wrongful retention? I mean, the structure of A is that you ask yourself whether where is the person habitually resident immediately before the retention, and then that gives the law by which you determine whether it's wrongful or not. So it's wrong, as we sometimes seem to do, is to say, when did the retention become wrongful? The issue is, when was the retention? And then that gives you the sort of frame of reference when you ask whether it's
Well, my
wrongful.
lord, it rather feeds into what my learned Lord Hughes said this morning about the question is not whether there's been a retention, but whether the retention has becomes
Well, I wondered
wrongful.
I mean, that was my immediate thought, but actually looking at the section, I'm not sure it's right.
Well, I have to say, my lord, we're not completely in line with that analysis, in the sense that when a parent makes an agreement with another parent to allow the travel of a child to another jurisdiction, in effect, they are exercising parental responsibility, their rights of custody in that permission for the travelling of the child, and not in a sense the retention of the child, but in allowing the child to, as I say, through the exercise of parental responsibility and rights of custody, to live with that other parent in another jurisdiction. It becomes wrongful retention at the moment where either the intention and the act together, or the acts are clear that it's intended to retain.
You accept there's got to be a point in time at which there's a retention. It can't be a process, as
Well,
Brandon told us.
my lord, I don't accept that, and I don't accept that. And in this case, my lord, it is perhaps an example of that. My lord, we can
Anyway, you don't
return to the
Can
judgment.
I just, assuming, I was going to go on assuming you did accept that, but if you don't, so be it. But to what was said in the passage quoted from the Australian case, this is at page MS 177, paragraph 92 of Lady Justice Black's judgment, which is an extract from the Perez Vera report.
Give me for a moment, my lord.
MS 177. Paragraph 92, and
Yes.
the Australian court thought that their view, which is consistent with Mr. Seabright's view, was supported by paragraph 108 of the explanatory report. The fixing of the decisive date in case of wrongful retention should be understood as that on which the child ought to have been returned to its custodians, or on which the holder of the right of custody refused to agree to an extension. So that's looking at it from the point of view of the father and saying, at what point, from his point of view, should it have been returned? And in a way, the question of what the other thinks or whether she communicated it becomes irrelevant. Now, is that a correct interpretation of the Perez Vera report?
Well, we can't agree with it, my lord. And we can't, therefore, we can't agree that it's a correct analysis of the report either.
Well, it's clearly the usual case. The question is whether it's the only case.
Yes.
That's the whole question in this appeal.
Well, thank you, my lord. Yes.
But I mean, the context was of the need to have a clear date by reference to the question of settlement, the sort of the other side.
Indeed.
But presumably you have to have the same, if you need a clear date for one, you need the same clear date for the other.
Well, my lord, yes, but as in this case, the Court of Appeal's determination, the majority of the Court of Appeal indicated that, in fact, it was likely on the evidence that the date of wrongful retention was by latest November the 4th. And that was because that's what the evidence, the preponderance of the evidence indicated, we would say.
Yeah.
Now, we say there's absolutely nothing wrong in that reasoning because you do have a clear date. But whether, my lord, it could have been an earlier date or whether it certainly wasn't beyond the 4th of November upon that reasoning. So I don't think, my lord, there's a difficulty there. We say in this case there is a clear date that the court could alight upon. In fact, that we ask and invite perhaps an unlikely conclusion from this court, that to invite this court to pick the date of the 21st of September as the date of wrongful
I mean,
retention.
your comment on the Perez Vera report is, as my Lord Hughes said, it's probably dealing with a normal case, but not necessarily every case. Is that right?
Yes, and my lord, it is an analysis.
You can't ask this court to do that.
Well-
You're not appealing.
No.
You're not cross-appealing against the remission to the judge to look again at November.
No, well, my lord, I'm in a sense sorry to get right to the very end of our written case, but given the length of time in this case, my lord, we're really grasping at an attempt to bring some conclusion rather than a further hearing. But if it's inevitable that there needs to be another analysis, then it is inevitable. But in terms of the evidence...
Well, I mean, yes, what is the evidence?
Well,
as a matter of interest, have we even
yeah.
got the content of the two
My lord, we have.
statements of the 21st of September? Where are they?
We have. And can I take you to them in the appendix bundle? And so, my lord, can I take you to, firstly, to the mother statement at MS 520. So in the middle of the appendix bundle, my lord sees this evidence. And then, my lord, can I ask you to look at
Can you just say, what is this? This is paragraph 37.
Yes, my lord, this is the
Statement of...
This is the statement of the mother, and then supporting the mother's evidence.
This is presumably made sometime after September 2016.
Indeed.
But it's the exhibits which are going to count.
Yes.
Okay.
And so my lord then turns on to 555, please. And this is the important document, my lord. This is the solicitor's letter to the Home Office on behalf of the mother. And this one is dated the 4th of November.
Well, that we've got quoted in Judge Bellamy's judgment.
You have.
Got that.
I'm taking you through the stage.
Okay.
So, my lord, the importance of that letter, absolutely crucial, and the letter upon which the majority of the Court of Appeal disagreed with the analysis of His Honour Judge Bellamy, and also, for that purpose, Lady Justice Blacks as she was. In the middle of that statement, my lords, on page 558, in the middle of the page, starting "it cannot," this was the presentation of the mother to the Home Office. It cannot be in doubt that the children's centre of life is and will be in the UK, where the children are registered as requested.
Yes, and earlier passages in the letter say things like she's been advised not to return to Australia.
I highlight only upon that for the very obvious reason there are previous comments, as my lord indicates, clearly having read this document. But that really, we say, is the high point in this evidence.
But we don't have the two statements
Well, my lord,
prepared in September.
we do. So I'm sorry if I'm taking it slightly
No,
slowly.
that's all right.
But moving on then to 559, so I'm scrolling down, my lord then sees what we would say is an infamous letter from Dr. Doug McLean. Now, his statement on behalf of the mother is dated the 21st of September of 2015.
Oh, I see, that's one of them.
And that document was part of the supporting immigration documentation for the Home Office. And then, my lord, scrolling down, a further letter from a Miss Bailey, dated the 28th of September. and a further statement, and then, my Lord, a further statement. I'm now looking at 562 from a Miss Johns, dated the 21st of September. So, of 2015.
Sorry, which is the...
And then there's two further statements.
What on page 562 are you relying on?
The date, my Lord.
I've got the date. What about the content?
Well, no, no, my Lord. The importance of it's not the content.
Oh, it's not.
Not of that letter. The importance is the date. Because you have, my Lord, the Home Office letter of clearly upon instructions that sets out, we say, as clear as it could be, the mother's intention. And she has obtained, no doubt before the 21st of September, but by the very least the 21st of September, statements in support of that application.
Oh, I see. So it's
just the fixing of the date.
It's the obtaining of the supportive letters, you say, that is the overt act.
It's simply a fixing of the date. That's the earliest date that we can fix upon. But
she might have obtained the letters in September.
yes,
In respect of a proposed rather different presentation to that which ultimately eventuated.
she might have done, my Lord, but this was evidence that was placed in support of the Home Office application. And it is the evidence upon which Lady Justice Sharp and Lady Justice Thirlwall alighted upon in their majority determination.
They didn't refer to September, did they?
No, my Lord, they didn't give you the date, but I can refer, my Lords, to what they made clear in the judgment was by the latest, the 4th of November, but it may have been considerably earlier.
Well, I think you can make the point that these letters are either exactly coincident or almost coincident with that of Dr. Maclean, and he opens his letter with the statement that he's been asked to support the application to enable the children to remain with her while she continues to live in the United Kingdom.
Exactly the point, my Lord.
Of course, that has to be linked to any statement that she intends to remain in the United Kingdom for a particular period of time.
And that,
Otherwise, it means nothing.
no, and conspicuous in its absence, my lady, of course, from the long letter from the Higher Court's advocate on behalf of this mother to the Home Office, presenting a case, conspicuous in its absence was any discussion of the agreement between this father and this mother. Never does it raise its head in the document. And we say, my Lord, my Lords, my Lady, that of itself was an overt act, albeit by its silence. And we would go on, my Lord, to say also, looking at the emails between the parents prior to the 4th of November and at exactly that time, the deafening silence of the mother to the various requests of the father to return the child to Australia and to give the date for return, the deafening silence of itself was an overt act of retention, which was wrongful. And so, my Lords and my Lady, the suggestion that in this case, on these facts, this father couldn't action a remedy under the Hague Convention of 1980 because jurisprudentially he should be barred until the end of the term of agreement, we say is absurd, would lead to an absurd situation. Now, the merge to, of course, ground two is that, of course, the father didn't know any of this until the trial process began. And at that point, there is then a shifting of position in terms of the trial process. That is of no surprise, nor is it anything new in this type of litigation, which is meant to be of summary nature and involves case management at speed, involves the production of statement evidence by the parties at speed, and often it's only when, my lords, my lady, that the evidence is produced with supporting information that more clarity comes into the arena. And so in this case, it became absolutely clear, we say, when this documentation, the immigration documentation, was disclosed, what the true position was. Now, on my learned friend's analysis, this father, in another case, would be denied the right to rely upon this information as information of wrongful retention, of evidence, forgive me, of wrongful retention. We would say that was absurd, and that a court properly considering a convention application for the summary return of a child, looking at this evidence, to be hampered, to be prevented from looking properly at it and saying, this was the point of retention on this evidence, again, with great respect, we would say, would be absurd. In terms of communication, my lords, it is not, we say, it cannot be right for the same reasons, that a intention to retain has to be communicated for it to be capable of being acted upon. If, my lords, it is an intention that remains in the head of the parent who has the child, that is one matter. And as learned Lord Justices, Lady Justices, forgive me, in the court below indicated, the likelihood is either the parent will act upon that intention privately held, or she won't. If she doesn't, the practical problem doesn't arise. If she does, then the intention will be supported and evidenced by acts that make the intention clear. So we say, my lords, this is a practical issue. It is an evidential issue. It isn't perhaps as sophisticated an issue as it might first assume the nature of. And the court below, in the significantly shorter judgment of the majority, support that position, that in fact a trial judge, armed with the information and the evidence, will be perfectly able to understand the evidence in support of a wrongful retention. It, of course, has to be intention. There has to be intention. But whether that intention must be communicated, we indicate in support of the majority in our respectful submission that does not need to happen. This is a classic example of that scenario. It would be wrong in principle, we say, for a court to be denied access to this information and for a parent to be denied the ability to rely upon it.
But those are two different things. Those are two different things.
Well, they are, my lady.
The evidence of what the intention was is one set of things, and it may contribute to a conclusion that it was an unequivocal intention which was bound to be acted upon. But that doesn't follow from that the left behind parent is stuck with the suggestion that he ought to have acted upon it when he didn't know about it.
No.
Really, I mean, the logical thing is for him to act upon it the moment he knows about it.
Yes. Yes. But if the issue, my lady, as in this case, the evidence doesn't arise until trial, the left behind parent, we say, could not be barred from relying upon the earlier date, simply because it wasn't communicated. That would be to lend support to, with respect, I think there's some of the comments made by my learned lords earlier this morning, to active deceit by a parent as a means to defeat a left-behind parent.
I'm afraid these cases do very frequently involve active deceit.
Well, our concern in this case, and we make it plain, our concern in this case is if there was to be an overturning of the majority decision below, that would actively support the prospect of a removing parent being able to actively deceive and rely upon that deceit, particularly in respect of the settlement defence. Being able
The settlement thing works the other way.
it works
It's
both.
the habitual residence thing that
Well-
is of help to you.
Well, it is, but my lady, we think the settlement thing works both ways with respect, because if the deceit is such that the removing parent says, well, actually, in fact, I didn't tell you, but I intended to retain after month 1, and we're now in month 13, and that was the point at which I retained the child. Now, it's a bold submission by a parent in those circumstances, but they would be entitled to rely upon a settlement defence in that circumstance. Of course, then the court considers the matter as a moment of discretion, and that's the important distinction
Yes.
between the habitual residence point and the settlement point. A settlement defence doesn't lead to an automatic return, my lords. It is a discretionary return.
That's certainly correct. In practice, our children, didn't say ever, but frequently returned after the 12-month period has passed and there is a finding of settlement.
My lord, I don't have the research to my fingers to enable me to honestly answer that, and it would be only my apocryphal view, which I don't think will help the court.
I think as a matter of practical reality, what my Lord puts to you is almost certain to be true. If the children have been here for more than 12 months, then it's going to be a pretty tough exercise of discretion to say, well, we're going to send them.
Well, at least if there's a finding of
Or if they're
settlement.
settled.
There might, of course, not be a finding of settlement.
No.
If there had originally been, if it's a sabbatical type case,
Yeah.
there'd originally been, everybody had planned on the basis they'd be here for 15 months.
Yeah.
Throughout the time they've been here, that they and both parents have been making plans for their return.
Yeah.
Yes.
You might easily have 12 months without settlement,
Yes,
And older children in particular.
particularly if they're older children, yes.
and if the older children throughout the period understand they're returning.
Yes, quite, yeah.
So
So you can have 12 months without settlement, but
Absolutely,
if
my
you
lord.
have got settlement, I just wonder whether there's any realistic prospect of a summary return under the 1988 Convention.
Well, my lord, I give my view.
No, you've answered that.
But the same point remains, but with greater force, my lords, with the habitual residence point, because it is the knockout blow to the Hague Convention application. And that's the distinction.
Well, it's still quite interesting, isn't it, the point my Lord has raised as to whether it is a knockout blow to the Hague Convention. But I think we may have to think about that a little.
As I stand here, my lady...
But
my
it's certainly not a knockout blow to the jurisdiction of an appropriate court to make orders about them.
No, absolutely.
That it isn't, yes.
But as I stand here, my lady, I'm confined, I think, to the previous jurisprudence, which would lead me to the conclusion that I've suggested. That
Yeah, no, you are, but that doesn't stop us thinking about it.
no, it doesn't.
And the odd thing about this, the sort of November date, is that we know that the application could have been couched in quite different terms, which wouldn't have given rise to any question of wrongful retention. From your client's point of view, he agreed to her coming to this country for a year and was clearly therefore taking the risk that she might acquire habitual residence here as a result of that one.
No, my lord, I don't accept that for a moment. He was taking, as he believed, no risk, because, my lord, remember the background to this case was that these parties had been in some dispute before. They'd been through mediation unsuccessfully.
Yes, I understand all that.
There was dispute. So the agreement, my lord, was a very clear agreement, firstly for a very short period, and then for a slightly longer period, and then finally for an absolute period of a year. There was clarity, my lord. It was either...
No, but I mean, from the point of view of the children, all the letters we've seen about them settling in and so on, there's nothing in that which would have come as a surprise to the father. All that is exactly what would have happened. The only thing that came as a surprise to him was the fact that this letter had been written in November, suggesting that the mother had changed her mind.
That came as an enormous surprise to him, coming as it
In
did to him
terms
much
of
later.
the habitual residence factors, nothing had changed at all.
Well, my lord, no. We say that in this particular case, this was, well, let me put it in more neutral terms, that habitual residence should not be found where there is plain activity on behalf of the parent who's removed and retained, forcing the roots into the ground, forcing the situation of habitual residence. Because in all the analogies, and the seesaw analogy that my lord, of course, in Reba gave us.
There's no evidence of forcing things on naturalists. I mean, basically, the children settled in. And obviously, presumably, the father would want the children to settle in while they were here.
My lord, I'm debating the facts isn't going to assist this court, I know. But at 6...
Obviously, it ties in with your cross appeal, of course, which raises these very issues. So.
At 6 months, within the year, so at the halfway point in this agreement, the father believing that the children will be returning to their Australian life.
Well, surely the simple point is that their continuing to live in the United Kingdom was conditional at all times, in his perception, upon his agreement. Therefore, the question of them acquiring habitual residence, that being a term of art, it didn't arise in his mind.
Never would it have occurred to him that by continually asking for a date for return, for his children to return to Australia, would there be embedded habitual residence.
Well, can one ask the same, I don't know whether one can, I'm just thinking out loud, can one ask the same question about habitual residence as I was asking you earlier about settlement? In the sabbatical type situation where everybody is working throughout the 15-month period on the basis of planning their return to whichever university it may be in Australia.
Yes.
Is there any question of habitual residence changing?
Well, my lord, we of course,
however comfortably ensconced the teenagers are for the time being in England, where's their habitual residence?
well, it is the place that they should return to prior to the agreement, my lord, of course.
Unless the concept of habitual residence actually extends even to that situation.
Yes.
But you would say not, I suppose.
Absolutely not.
Right.
And when my Lord Carnwath says he's taking a risk, that's not, that, with respect, is not what the convention says. What the convention says is, if a parent wrongfully retains in another jurisdiction, that it provides a speedy remedy to prevent that. Now, my lords, my lady, moving on, I'm in a sense moving back to ground one, but within our written statement, we posited 5 reasons why the five reasons why our interpretation in support of the majority of the Court of Appeal is the correct interpretation, that there ought to be a preemptory, some principle of preemptory retention, or I think as we would prefer, Lord Hughes's analysis, that simply this is about wrongful retention. And so in our documents, my lady, my lord, at 109, MS 109, so returning to our written case, we respectfully say there are 5 reasons why. I'm not going to read them out other than to extend the headings as it were. The principle is consistent with the purpose and aims of the Convention of 1980. We say absolutely that must be the case, because it cannot be a purpose of the Convention that a unilateral act of a parent in retaining a child against the express wishes of another parent, and that amounting to a breach of rights of that parent, could be consistent with the aims of The Hague.
But it isn't. The unilateral act of a parent in breach of the rights of custody of the other parent is a ground for instant return of the child under the Hague Convention. The only question is, when does that...
Forgive me, that was inelegant. It cannot be consistent with the aims of the Convention
To stick to the date
To stick to
mentioned
the
in the
date.
convention, yeah.
It cannot be, with respect. And one can look at a variety of scenarios around it, but we say, and we hope forcefully, that the aims of the convention are very clear and not supported by a suggestion that you have to wait to the end of the term. It's consistent with other international instruments, we say, and we set out there the United Nations Conventions on the Rights of the Child and the Charter of Fundamental Rights. The principles are also consistent with the wording, we say, of Article 3 of the Convention. The underpinning of that approach, child's removal from state A to B, pursuant to the agreement of both holders of parental responsibility, represents an agreed exercise, as we said earlier, of parental responsibility by the left-behind parent to determine in which country the child lives. The agreement, the right to veto point, which has already been discussed. The principles promote the child's best interests. That must, we say, be right. It must be right that a left-behind parent is able to take steps, active steps, to have a child return to the country from which it was taken if the child is wrongfully retained within the period of a termed agreement. It promotes the child's best interest for there to be a remedy for that parent. We say also, of course, this is not the first time that the courts domestically have dealt with this issue, and a variety of first instance decisions accord with this principle. The issue of consent was raised by my learned Lord Kerr this morning in terms of deceit and consent. Well, it's consistent, of course, also a principle that we promote in support of the decision below with how the courts have dealt with consent. That consent, of course, is vitiated by acts inconsistent with that consent. The consent becomes non-consensual if acts by the other parent vitiate, be those acts of deceit or otherwise. The point that was made by my learned Lord Kerr earlier is absolutely right, that if a child is removed, and it's a removal case rather than retention, by deceit, by making the left-behind parent believe something different is going to happen, then that consent is vitiated. We say it's entirely consistent with that analysis that after a lawful retention in another country, that retention becomes wrongful if the terms of the agreement are unilaterally changed, fundamentally changed. We use fundamental not in the terms of the contractual principles, because as my learned, my lords and my lady may have seen, we've perhaps moved away from the concept of parallels with contract law, agreeing with Lady Justice Black that the principles within contract law won't really assist this court in the analysis of the appeal. And that appears at 1.1.10, the reasons simply in support of that position. My lords, can we then turn to the judgment of the Court of Appeal and to the decisions of the majority in the Court of Appeal? It's 38. I'm going to start there, in fact. This one. I'm sorry, my lords, dealing in the e-references and the non-e reference in my bundles, but could I ask you first to turn to, please, MS page 186, before we get to the decision of the majority of the Court of Appeal, and deal, firstly, if we could, with some of the aspects of Lady Justice Black's judgment. My lords, my lady, paragraph 113, 114 we've already considered, but given our interpretation in this appeal, I wanted to refer, if I may, back to them. Given the careful structure, this is Lady Justice Black, given the careful structure of the Convention with its inbuilt safeguards to protect individual children from harm, it seems to me that it would be unfortunate if a parent could control or influence the outcome of application tactically in this way. In saying this, I do not overlook the argument that it's the parent who's gone back on the original agreement who is at fault, and that the left-behind parent should be given whatever tools are available in order to minimise the scope of taking advantage of that fault. Well, my lords, my lady, we say that is absolutely central to the Hague Convention of 1980, to the principles underlying the Convention. And that really any decision of this court in interpreting wrongful retention in this type of case, which we say is a rare type of case, of course, should be consistent with those inbuilt safeguards.
Mr. Hale, are you not, in drawing our attention to paragraph 113, drawing our attention to Lady Justice Black's rejection of the rather curious election argument of your predecessor?
I am, my lord, but focusing at the same time upon the careful words of Lady Justice Black in respect of the Convention. And that an interpretation of the Convention supports, we say, powerfully why the majority of the Court of Appeal were right. The issue of election is, my lords, the concern perhaps expressed in terms of tactical manoeuvring within a case of this type. But it is not something that's unusual in Hague Convention cases for there to be a difference of opinion as to picking of dates for different outcomes. Ultimately,
That's different. The difference of opinion as to picking dates is quite different from actually having a choice of dates.
What the argument that was being advanced, as far as one can tell, was that the left-behind parent was entitled, as it were, to nominate a date whenever the judge, left to himself, might have thought the retention became wrongful.
well, my lord, the way in which we put the case,
It's not persisted in, Mr. Hale, so
No, quite,
that's
it's
not
gone.
trouble with the election area of the judgment.
and so I wasn't, my lord, and thank you for taking me on. That, we say, is the clearest of statements.
You want the bit about going back on the agreement, do you?
I do.
Okay.
I do. And we say it was entirely the correct analysis by Lady Justice Black, which led her, my lords, of course, then turning the page to MS 189, to the analysis at 127. And this was the submissions made by learned friend earlier about section 13 situations, which we say, with the greater respect, is a little of a red herring in this appeal, and not something that needs determination by this court. The situation within a parent who has a right to remove for a period of time is not before this court under section 13. We are concerned, of course, with a different concept. But in terms of that analysis, my lords, I pray and aid that paragraph from a third of the way down. I was initially attracted by the idea. Well, having initially been attracted, Lady Justice Black, of course, was properly diverted and upon reflection. and looking at those positions differently. Of course, they're very different, my lords. They're very different propositions to the situation, which is, of course, an agreement breached after as we say, about 6 months. 6 months or just before. In the analysis, Lady Justice Black refers to Mr. Justice Wall, as he then was in Ries, and that important, although simple sentence about taking the benefit of taking them abroad and the burden of returning them. It's that burden of returning them and the breach of that burden which converts the retention into a wrongful retention. It must be right, therefore, that within the period, if that's when it happens, we say that a parent is entitled to act. Can I then move on, if I may, to the decision of the majority in the Court of Appeal, further in that judgment, because I'm not sure you've been referred to it yet today, it being the decision that's under appeal. But if my lords, my lady, considers from MS 206, starting at paragraph 178, my lords, my lady will remember that what Lady Justice Sharp and Thirlwall did was they set out the entire aspect of the judgment concerning His Honour Judge Bellamy's discussion of the heading wrongful retention, and then analysed carefully what that meant. And I've taken you now to the British citizenship documents, and so you have the context that the learned Lady Justices were referring. On a fair reading of this section of the judgment, starting at paragraph 178 on MS page 206, on a fair reading of the judgment, it seems to us the judge really addressed two issues. First, whether the mother said through her solicitors that the position of the children was necessary for the purposes of the Home Office's decision, etc. And secondly, what, if anything, could be deduced from the fact that the application had been made, in particular without the father's knowledge. And as we read what he said, the judge concluded that since the information was unnecessary, because the issue was whether the children met the statutory criteria and was not one of discretion, it could not be said that the Home Office had been misled into granting British citizenship by false or misleading information. Well, pausing there for a moment, my lords, that, of course, we say was a fundamental error of the learned judge in the first instance, taking into his reasoning at that point throughout the rest of the determination he made, including as to habitual residence.
But it isn't relevant at all whether the Home Office was misled. Surely the relevance of this evidence is what it tells us of the intention of the mother.
Absolutely.
And it's not whether the Home Office was misled or not.
Absolutely.
I mean, the judge is right to say that these children were entitled to British citizenship, but your riposte to that is, well, that's neither here nor there. I mean, it's what the evidence tells us about the disposition of the mother that is the pertinent point.
It was a clear act.
Mr. Hale, could you give us the reference in the bundles to the cross-examination of the mother about the solicitor's letter and the surrounding documents?
I can.
We needn't turn it up, but speaking for myself, I'd like to discover it and consider it overnight.
Yes. So, my lord, a matter that my learned junior will herself intending to speak to, but it's at MS 631 in the bundle.
631 to...
631 onwards, my lord.
Very well. Thank you.
You'll see that's the passage in the cross-examination where the mother deals with the questions, direct questions about the Home Office documents and the other statements. So, my lord has now, no doubt, already read paragraph 180, my lord, Lord Kerr. I won't then read it out, but of course, my lord alighted immediately upon the reasoning of the Lady Lord Justices in respect of this evidence. the judge failing to consider or address the key issue when considering whether the circumstances surrounding the children's application for British citizenship amounted to anticipatory retention. We say wrongful retention at that point, having regard to the importance of the point. He should have done so. Well, that's central, we say, to why it is that the majority of the Court of Appeal were wrong on this issue in terms of communication. The agreement, of course.
What we've been looking at, surely, is really in relation to their decision that the November material had not been properly considered and should go back for redetermination.
Yes.
So really, this material goes to the proposed third ground
Well, my lord,
of Mr. Setright's appeal. And on the second ground, no need for communication. Where's the reasoning of the two lady justices?
in terms of communication,
Yes.
well, thank you. 176.
Well, that's a conclusion. Where's the reasoning of the two lady justices?
Well, my lord, I don't think that Lady Justices Sharp and Thirlwall dealt with the postscript. I think that is right.
Script clearly came after their judgment, didn't it? That's
So I don't think they got a chance. It was rather my point, my lord. I don't think they got a chance for a postscript.
But is there anything anywhere about why?
Well, they wouldn't have needed a postscript
No, they wouldn't.
to disagree with her very clearly expressed conclusion that communication was necessary.
It wasn't necessary, yes, indeed.
Yeah.
It was a clearly expressed conclusion that, in their
I mean,
view,
you find it in two different places in her judgment.
we do.
Um,
I think it starts at one.
but they don't really address it, do they?
They don't in detail. I have to. I think, in my respectful submission, it's not dealt with in detail because they rather take the view that it's fairly clear that in this particular type of case, my lord, in terms of communication, the evidence wasn't available to this father until the trial. The mother didn't communicate the information to him at a time at which, particularly with the Home Office information, she should have. There's no question about that.
You're straying into the facts of this case.
Well, I am.
We all know that there was no communication.
Indeed.
The question is whether any principle of premature retention requires communication. That's the issue
indeed.
of principle.
So can I move on then, my lord, into our written case at page MS 128, where we set out what we say about communication.
Well, now, what Mr. Setright, I mean, I've struggled with the word communication. It's borrowed, of course, from the Court of Appeal, so no one can be blamed for using it.
It is.
But when I asked Mr. Setright what he meant to refute, what he meant to refute was the possibility that a purely secret intention, never manifested in any way overtly, could amount by itself to a wrongful intention. I think I wrote down accurately that his submission was that what you have to have, assuming that the concept is possible at all, what you have to have is a decision which is objectively apparent from something that's been done.
And apparent to the left behind parent.
Well, it becomes apparent at some stage to the left behind parent.
And so we deal with that.
It doesn't have to, in other words, I don't think he's contending that before there can be any wrongful retention, the travelling parent has himself to tell the left behind parent.
I thought he was contending, but one way or another, there has to be a communication from somebody to the left behind parent before the retention becomes wrongful.
Well, at all events, what is it that you're saying is the question that we're addressing?
Well, my lord, what we say is that in the vast majority of cases, it will become clear to the left behind parent by the actions of the retaining parent what their intention is.
But it didn't happen so to be in this case.
And so there will be cases where for example, the first time that the intention becomes clear is, as an extreme example, in the witness box. So this mother, in this case, gave evidence and said to Malone Jr. in answer to her questions, by April, we weren't going back, I paraphrase. But I knew by that point we weren't going back. She'd never put that in a statement. Now, as of course, my lord, it happens, answering your question, in this case, the reason I focus upon the earlier evidence is there is, we say, very clear other evidence of the intention significantly earlier than April 2016, autumn of 2015. The answer to your general question, my lord, is that very often there will be some information around, or evidence around the intention.
We're not dealing with the usual case. We're dealing with the requirement of the principle.
Yes. Well, my lord, we think that the cases will be determined by their facts. And on the principle, we say that a intention does not need to be communicated. If it did, it could lead to absurd results.
Do you mean by that it need not come to the knowledge of the left behind parent?
No, my lord.
I didn't think you did.
No.
What do you mean? Need not be communicated.
It need not be directly or indirectly communicated by the...
What you mean is that the left behind parent can rely on it, rely on an earlier date, even though he only learns of the material that leads to the earlier date much later.
So the best example is here, where having evidence of emails of asking for the date for return, there's a deafening silence. And then the father has to take a decision about bringing an application.
So you mean by doesn't have to be communicated, the travelling parent needn't speak directly to the left behind parent?
I do.
Right.
I do. And, my lord, there has to be evidence in support of the intention.
Yeah.
And, my lord, we deal with this at paragraphs 63 through to 65 in MS pages 128 and 129, where we set out options. My lord, A, private intention of the respondent not to return, not communicate in any way to left behind, not manifesting in any way by virtue of a unilateral action or step taken further to the said intention. Well, that, my lord, if there's no evidence of it and it's not acted upon, it's impossible to say how that could be something that the left behind parent could act upon.
But if it turned out that it was proved in evidence, for example, by an admission in the witness box, that's it, you say that's enough, do you?
It must be,
Right.
my lord, because it would lead otherwise to a judge. Well, what would be the alternative answer? That a judge would have to ignore it, or the parent couldn't rely upon it.
Okay.
It's an admission against interest on that point. It must be able to be relied upon. And so B, C, D and E are the other points, my lords, my lady, that we pray in aid. And all, as we say at 65, all the above options are capable of amounting to an anticipatory retention. Further, in tandem with the above options, when identifying the words or conduct on the part of the respondent amounts to an anticipatory retention or wrongful retention, we say a helpful cross-check are the markers of integration in the assessment of the child's habitual residence, both subjective markers, the intention of the respondent parent, and the objective markers, actions or steps taken to further the child and or parent's integration. It's rather my forcing the roots point. Forcing the roots down in support of habitual residence, making the case. We say, in breach of an agreement, those objective markers can be relied upon as evidence communicating an intention to retain. So such markers allow it to be clear and tangible that the intention is not to return. We deal, my lord, with how it was that His Honour Judge Bellamy dealt with that on the next page at MS 130. My lords, I want to, if I may, move on to deal with the issue of other remedies that was addressed by my learned friends this morning, if I may. And understanding and considering my learned friend, Mr. Setwright, Queen's Counsel's responses to questions, we wanted, if we may, to make the following submissions. I've made the preliminary point, which is that this is an appeal about the 80 Convention, not the other conventions or other domestic positions. The return of a child, as opposed to breach of access, are two extremely different things. Of course they are. And this case brings that into stark form when we are considering the UK and Australia. The idea that our client could not a father in this position could not bring proper remedy for return, we say, is quite different from any arguments about breach of access under the conventions. My lords, forgive me. The automatic funding under the Hague 1990 Convention is not something that can be possibly disregarded. It's not available in 1996 cases. And I have to tell my lady and my lords, it's not a matter that's missed by Mr. Justice Mostyn in these cases. He has, in various cases, reminded in his judgments, reminded us of that position, that it is in these cases, in the 1980 cases, where there is automatic funding. Of course, in the other convention cases, 1996 convention case, or for that matter, BR2 returns, there is not automatic funding, it is merit-based.
Mr. Hale, forgive me if I'm wrong. We are, of course, concerned with the interpretation of the 1980 Convention.
Yes.
That is the question before us. My understanding is that the states parties to the 1980 Convention are not required to provide automatic, non-means-tested legal aid for left-behind parents. Some of them do and some of them don't, and they do it in very different ways. When considering what the parties to the Hague Convention meant by it, when it was, and we can take subsequent events into account, but surely it's completely irrelevant that in this country we have such a generous arrangement for legal aid for left-behind parents.
My lady, I pray and aid only in this way, that in this case, dealing with this appeal, it has been suggested by the appellants that the fact of other possible remedies is a reason why this appeal can be permitted.
Yes, well, that's an interesting question about whether subsequent international agreements, which have definitely changed the picture, the context within which the Hague Convention operates, are relevant to the interpretation of the Hague Convention. That's an interesting question. But I believe I'm right that the Hague Convention does not contain an obligation to...
No, my lord, my lady, I accept that.
Yeah.
Accept that immediately. But it's relevant for this reason that simply, well, my lady, can I move? I'll move on to the other remedies suggested and deal with them if I may.
Some people do it.
My lady, we dealt earlier with Article 7 and Article 10. The suggestion was that this father could have gone to an Australian court and sought an order. Well, and then enforce that order in the UK. But practically, one has to look at what that would involve. Even if there was jurisdiction, the Australian court would first have to determine, of course, habitual residence. And my learned Lord Wilson took my learned friend to aspects of that, and we entirely endorse with respect the difficulties of a foreign court on the other side of the world dealing with that issue, that fundamental and first issue for them to deal with in terms of jurisdiction. But it doesn't end there. For an enforceable order to be made, an order that can be, forgive me, enforced in this country, there would need, of course, to be an inter partes hearing. In Australia, we don't believe there's any automatic funding for that. That's simply a fact. The assessment would have to be a welfare assessment in Australia, and the child or children would have to be heard, or how their views and wishes were to be considered would have to form part of the analysis for that order to be enforceable in this jurisdiction. It's a practical consequence. If not, then if any of those aspects were not available within or part of the decision of the Australian court, that order would then be challenged in this court as not enforceable. Then to the UK to enforce that order, well then the application again would be made. The alternative to that is, of course, the 1980 Hague Convention, the subject convention of this appeal, a summary process meant to be, of course, a process that takes 6 weeks. It happens that this jurisdiction does fund applicants without the need for there to be a merits-based assessment. What's the alternative, other alternative to that? Well, my learned friends say, well, there could be an application under the inherent jurisdiction for summary return. Well, that, of course, would involve the applicant first accepting the jurisdiction of this court. The habitual residence aspect, the jurisdiction of the court to make the order for summary return. It is, we say again, unrealistic for the same practical reasons. No automatic right to funding in this jurisdiction, litigating on the other side of the world, a welfare assessment rather than a summary assessment under the 80 Convention. But here is, we say, the fundamental reason why that analysis, the analysis that this court should consider the other remedies as reasons why this appeal should be allowed. Here's the real reason. There are 49 countries, 49 other countries that are non-Hague Convention 1996 or B2R countries, 49. And so as an example, my lady, my lords, if we chose Canada as an example, it is not a signatory to the 96 Convention and plainly and obviously not subject to the rules of B2R. What would happen in a Canadian case? Well, there wouldn't be the availability of Articles 7 and 10, plainly. There could be a Canadian application in Canada. That order could then be made and then that order brought to this jurisdiction. There isn't any bilateral agreements that could be relied upon, and that there would then simply be a welfare analysis in this jurisdiction on that basis. The time that would be involved in that type of application in a country, a Hague Convention 1980 country, but not a 96 Hague Convention country, the time that that would take with respect would be not commensurate with the interests of children, of the child subject to the applications. It would amount effectively, my lord and my lady, to a leave to remove application in this jurisdiction, because the test would be effectively the same. Whether you ask for it on a summary basis, the welfare analysis would amount to the same. And so, for those reasons, we say plainly that the suggestion that there are other avenues that protect a father in this situation, such that the concept of anticipatory retention or wrongful retention, as we say, within the term, should not, by this court, be considered to be a principle upon which a father should act. It must be considered in the light of the reality, the practicality of a father faced with the reality of a child on the other side of the world held in breach of an agreement. The advice that international family lawyers would give if this was the case would, we say respectfully, amount to a very difficult situation. If a separated parent sought to move to another country, Canada, let's say, to the UK, and let's, for the purpose of this scenario, say it was to care for an elderly parent, but they had a very young child. If in fact the same scenario arose, what advice would be given about the ability of that left-behind parent to bring proceedings if in the term the other parent decided to retain? It may lead to international advice that advised parents to be super cautious in circumstances where, as my learned Lord Carnwath said, wasn't he taking a risk? Now, that may well be the scenario that forms part of advice to parents with children who are moving internationally, if what we say is the fairly simple concept of anticipatory retention doesn't form part of our law. My lady, that's very nearly 4 o'clock.
Very nearly. Have you ground to a halt? You've got 5 more minutes. If you have ground to a halt,
I'm going to grind to a halt, my lady, yes, because then I shall be quicker in the morning than I am now.
No, that's a promise. Hold you to.
2 seconds.
it seems to me there are risks on both sides, aren't there? I mean, there are risks about allowing children to be taken halfway around the world for a limited period. There are equally risks about doing anything in relation to them other than making the decision not to return right at the last minute.
Yeah.
I mean, it all depends who you're advising, what the risks are.
Yep.
Well, you will be able comfortably to complete this hearing in 2 hours tomorrow morning, I take it. Apologies if the change of the timing has caused any professional difficulties to anybody, but you didn't shout and scream and yell when we proposed it, so presumably it didn't. Anyway, we'll look forward to hearing from you further at 11 o'clock tomorrow morning. The court is now adjourned.